The child custody evaluation must use multiple methods of data gathering. That means that the psychological evaluation is put within the broader context of forensic evaluations in general. So it will consist of clinical interviews of the parents and of the children, of observation of the parents with the children. It will consist of review of collateral sources of information. So you will want to get material from friends, from family, from teachers, from other people who have observed the interaction of the parents with the children. Um, you want to be able to have all parties involved. Of course, if one party, for whatever reason, either they do not want to participate in the evaluation, or their attorneys have told them not to participate in the evaluation, then of course the psychologist cannot make a custody recommendation. You can do a parenting evaluation on the parent who is able or willing to participate, but you cannot say anything about the person who is not willing to participate. You want to avoid the situation that so often occurs where the psychologist decides what the person's motives are for not showing up for the evaluation, and then attributing some sort of negative meaning to that. One psychologist whose report I read recommended custody to the father because the mother did not come to the evaluation. And the psychologist actually said in her report, well, that shows what sort of a mother she is. We don't know that. The mother may not have shown up at the order of her attorney, or for some other reason. So we cannot infer what a person's motives are. Another case very similar, when the wife would not appear for the evaluation, the psychologist concluded that she was not a good mother, when in fact the reason that she did not show up was that she had been abused by the husband and did not want to be in the same room with him or interacting with the children in any way that would involve the husband as well. So do not make any inferences or evaluations of people who cannot or will not participate in the evaluation. And of course, this goes again to a part of the Ethics Code, section 9.01, that talks about the limits of the evaluation when parents do not cooperate, namely when certain data is missing. You have to qualify your conclusions in light of the missing data. There is always in custody evaluations the concern about what is called the ultimate legal issue. This is which parent will gain custody. There are legitimate disagreements in the field. Some psychologists say one should never address the ultimate legal issue. Others say you have to address the ultimate legal issue because that is what courts are requiring. We cannot, within the course of this webinar, we can't really discuss all of the issues involved except to say that there is legitimate disagreement. The most we can say at this point is if you do make a recommendation as to the ultimate issue, be sure to base it on data. Be able to say that this parent should have primary legal custody for the following reasons, and cite all of the data in support of that. Do not allow it just to come off as a pronouncement without data. And again, it goes without saying that you have to have comprehensive documentation. Okay, now I want to turn to the specialty guidelines for forensic psychologists. This, as I said before, was recently passed by APA Council on August the 3rd of 2011. It replaces the specialty guidelines for forensic psychologists that were published in 1991. Which were never officially made part of APA doctrine. They now are, and that's an important difference. The old specialty guidelines for forensic psychologists are, in fact, part of Florida law in section 64B19-18.007. So here is another example, like the old child custody guidelines, which, while in their initial form they are aspirational guidelines, they are not enforceable standards. Once they become part of the Florida law, they do become enforceable standards for psychologists practicing within the state. Now, what a few things that distinguish and make these new forensic guidelines so important is the actual definition of forensic psychology and what is not forensic practice. Recall when we were talking about the child custody guidelines, we made a distinction between psychologists conducting custody evaluations and those performing psychotherapy who became involved in a court proceeding, though they had not intended to do so at the time that they commenced the therapy. So the definition basically talks about a forensic practice, forensic intervention, forensic treatment, as occurring when there is what the guidelines call definable foreknowledge, that the psychologist is going to be answering specific psycho-legal questions. In other words, the evaluation is designed to answer certain questions, such as, is this person competent to stand trial? Are they criminally responsible? Do they have certain kinds of mental or emotional problems that would interfere with their being able to understand and appreciate their Miranda rights? These are just some examples from the criminal law. Of course, from the family law, as mentioned before, there are particular personality characteristics that make them a good fit or not such a good fit for the particular needs of a child. Within a personal injury evaluation, does this person have certain psychological or neuropsychological characteristics which can be related to a particular accident or injury? That is what is called a psycho-legal question. And the important thing is that the evaluations start off with that as a focus, that there is a particular psycho-legal question being addressed. Again, the concept of definable foreknowledge. So if a person sets out to do psychotherapy and later gets involved through no fault of their own, no intention of their own, they get pulled into court to testify, that is not regarded as a forensic evaluation. A therapist, for instance, who does treatment with a sexually abused child or someone that they believe to be sexually abused, and later gets pulled into court when one or the other party is contesting whether or not there really was sexual abuse of that child, and they're calling on this therapist for their opinion. That is not a forensic evaluation, because it was set out, it was designed to be a therapeutic relationship, not a forensic relationship, for all of the same reasons that we talked before about not mixing those roles. So what is not forensic practice? When one sets out to do something different and later becomes involved without definable foreknowledge in some sort of a forensic setting, or performing a therapeutic intervention, or even a diagnostic assessment within a correctional setting. When you are evaluating the individual for purposes of developing a treatment plan, providing some sort of treatment, it is certainly within a forensic setting. It is a correctional setting, but it is not a forensic activity. It is a therapeutic or diagnostic activity. So, returning the bottom line, it is forensic only if it is set out or designed to be forensic. Someone cannot come along after the fact and say, well, you were doing forensic work, when in fact you were doing therapeutic or diagnostic work, and it happened to be within a forensic setting. There has been an unfortunate attempt to try to use these guidelines to define a standard of care in civil cases and in criminal cases. The specialty guidelines were not intended to be used as providing a standard of care, nor was the ethics code. Many things go into the definition of a standard of care other than these actual documents. It is unfortunate, but many psychologists continue to use these documents as the standard of care. There are many things within these documents that have to be modified, say based on a particular geographical setting, based on the state of knowledge in a particular area. That's why these are called aspirational. They are not practices that may be available to all psychologists under all settings. And so it cannot be regarded, nor should it be used as a standard of care. We mentioned before, in talking about the custody guidelines, the issue of impartiality, and that becomes even more clearly spelled out here. Now, in forensic work especially, it can become somewhat confusing, because when a forensic psychologist becomes involved as an expert witness, they are usually testifying for one side or the other, and they can be seen, therefore, as an advocate of one side or another. In fact, they are not advocates for one side or another. They are advocates only for their own opinion. That opinion is to be reached by impartial, objective data gathering. Now, once that material is integrated and put together, and as is stated very clearly in the specialty guidelines, all plausible rival hypotheses are tested through the use of multiple data sources and multiple sources of information. Once all of those are put together, and the psychologist decides that there is more evidence favoring this one interpretation than another interpretation, then that psychologist can advocate for their opinion based on that data. So really, one is an advocate only for one's opinion, not for one side or another. The impartiality goes into the process of data gathering. We talked before about avoiding conflicts of interest by avoiding the multiple relationships whenever possible. There are situations, of course, in which multiple relationships cannot be avoided. These may be situations when you are in a small community, when you are the only psychologist in town, when certain facilities that you would hope to refer the person to do not exist unless the evaluee were to travel 200 or 300 miles. Well, there are certain circumstances where these multiple relationships cannot be avoided. Under those circumstances, we have to proceed with caution. We have to be aware of the potential conflicts that it can cause, acknowledge them up front, qualify our conclusions in light of that data.